Hello, my name is Carrie Bacon, and I am here to discuss the legal risks my company, Beat Lifestyle Entertainment, may face in the entertainment industry. Starting with number one, breach of trust and contractual obligation. As seen in the Taylor Swift vs. Scooter Braun and Big Machine Label Group. In 2019, Taylor Swift publicly criticized music executives Scooter Braun and Big Machine Label Group for acquiring the rights to her master recordings, alleging she was not given the opportunity to purchase them herself. When Braun's media company, Ithaca Holdings, had acquired Scott Borche's Big Machine Label Group for $300 million. Through the deal, Braun became the new owner of Swift's first 6 albums with Machine Records. This case highlighted the importance of a clear contractual agreements and due diligence before signing contracts, as well as the need for artists to retain ownership and control of their creative work. Taylor Swift's main legal claim was breach of trust and contractual obligations by Scooter Braun and Big Machine Label Group for acquiring her masters without her knowledge or consent. The outcome was Swift's public outcry resulted in increased awareness about artists' rights to their master recordings and the need for transparency in contractual agreements. In less than a year and a half after acquiring them, Braun sold Swift's master rights to Shamrock Holdings, which is Disney, for over $300 million. The same month, Swift shut down rumors that she purchased her catalog from Braun, revealing that the sale had occurred without her knowledge. Taylor resulted in re-recording all of her records to make them hers. Risk reduction methods would be a clear contractual agreement. Artists should ensure that contracts clearly outline ownership and control of master recordings, as well as provisions for purchasing rights or royalties. Also, due diligence. Before signing contracts, artists should conduct thorough due diligence to understand the implications and potential risks associated with the agreement. The second risk is breach of contract, as in the Kesha vs. Dr. Luke case. Singer Kesha filed a lawsuit against former producer Dr. Luke in 2014, alleging sexual assault, harassment, and emotional abuse. The legal battle brought attention to issues of power dynamics and contractual obligations in the music industry, as well as the importance of documenting and reporting incidences of misconduct. Kesha's legal claims include allegations of sexual misconduct, breach of contract, and emotional distress against Dr. Luke. The legal battle garnered significant media attention and sparked discussions about power dynamics and contractual obligations in the music industry. After 9 years, the case details were not disclosed, but a resolution was agreed upon. But earlier in the case, Kesha was ordered to pay more than $373,000 in interest and royalties. Risk reduction methods would be documented agreements. Clear contractual agreements should be outlined, boundaries, and rights of both parties involved in professional relationships. Also, reporting and documentation. Artists should document incidences of misconduct and abuse and report them to appropriate authorities for investigation and legal action. Number 3 is copyright awareness, as in Rihanna's unauthorized use of photos in 2019. Rihanna was sued by a freelance photographer for allegedly using the photos without permission on her Instagram account. These were photos of Gigi Hadid for a Fenty ad. The case underscored the importance of obtaining proper permissions and licensing for copyrighted material, as well as the need for clear communication and documentation in contractual agreements. The photographer's claim was copyright infringement, alleging that Rihanna used the copyrighted photos without obtaining proper permissions and licensing. The case was settled out of court, with Rihanna reportedly paying an unenclosed sum for the photographer to resolve the dispute. Risk reduction methods were permission and licensing. Artists should obtain proper permissions and licensing for using copywritten material, including photographs, to avoid allegations of infringement. Also, copyright awareness. Artists should educate themselves and their teams about copyright laws and regulations to ensure compliance and avoid legal disputes. Implementing best practices in the entertainment industry involves various strategies aimed at minimizing legal risks, ensuring compliance with the industry standards, and fostering positive relationships with artists, partners, and stakeholders. Here are some key practices my company will implement. Number 1, drafting clear and comprehensive contracts that outline all terms, conditions, and expectations for all parties involved in business transactions. Contracts should cover areas such as rights, ownership, royalties, payment terms, creative control, and dispute resolution mechanisms. Number 2, conducting regular legal reviews of contracts, agreements, and business practices to ensure compliance and relevant laws and regulations. Work with experienced entertainment attorneys who specialize in the industry to identify potential risks and mitigate legal liabilities. The last would be to protect intellectual property assets such as trademarks, copyrights, and patents through registration, licensing, and enforcement mechanisms. Implement policies and procedures to prevent unauthorized use of infringement and intellectual property rights. Thank you for listening to my presentation and the best practices my company, Beat Lifestyle Entertainment, may implement in the future. Thank you.